I think it's the moment to announce that there is a prize for the survivors. It will be in this evening in the dinner. I'm sorry, Ron. Now, the last presentation is the Paul Roberts one. Paul Roberts is from University of Nottingham, and it's like all the day without introduction, without presentation. It's your time, and if you could to present the paper in 30 minutes,
yeah,
maybe,
should be. We'll give it a go.
And then we have the time for the debate.
Well, thank you so much, Geordie. Thank you so much for the invitation. Delighted to be here. It's been a great 2 days so far. I hope not to spoil that at the end. I've learned a great deal. It's been great fun. Thanks also to Carmen for organisational and the faculty. Really enjoyed it. On the same lines as Geordie's introduction, thank you and well done to all of you still here, my fellow panellists, all, I'm checking eyes, all still awake. We kind of had to be here, but you people, you're hardcore. You didn't have to be here, so thank you for sticking with it until the end. Second prefatory remark connected to the first, I'm always extremely conscious when I come to, as I'll call it, continental Europe, that I'm typically, always in fact, invited to speak in English because I wouldn't be able to give a presentation in any other language. Very conscious of the fact that I sit here in another country discussing with people who are also using English in maybe their second or third or ... N language. So I'm appropriately humbled by that thought that I can come here and speak English to you today. I'm not sufficiently ashamed on a cost-benefit analysis to learn Spanish in the next half an hour, but I am at least cognizant of the fact that we use English as a lingua franca, to use some Latin, in comparative law and legal theory, is both a facilitator and a constraint. You know, there are serious problems of translation that add to the difficulties that we've experienced in doing interdisciplinary, multidisciplinary work over the last couple of days, which I hope will go forward. So I just wanted to acknowledge, humbled by the fact that we're using English, also to be aware of the challenges that translation poses, particularly in analytical areas where linguistic precision is so important but difficult to achieve when translating from one language to another. Of course, translation always involves transliteration. It always involves change of language as well as translation. Just a final very brief remark. I don't want this moment to pass without mentioning Craig Callan's passing, a friend who often discussed these topics with many people here. Craig sadly died about a month ago now. It's a sadness to record that we won't have the opportunity of debating these issues further with Craig. On a more upbeat note, delighted that we're meeting new friends, new colleagues here, taking that forward from today. So that was a bittersweet remark. I'll get on with the paper. You'll be aware, you will have noticed that my paper looks a bit different to most, if indeed not all, of the papers presented over these last 2 days. The most obvious reason is the thickness, the length. I think the Russians have a phrase about this book was big enough to kill a man, you know, hit him on the head. I don't know, my paper's not quite that thick, but I appreciate it's long. Now, I do apologise for the length, but there's a reason for it. And the reason also explains the difference in a more profound way, and it's this. It's a methodological difference, and it's this. Nearly all the papers we've heard this last 2 days have presented general accounts, generalised accounts, sometimes using detailed examples for the purpose of illustration, but in general, they've gone from the general and they've used the particular. Now and again, they've presented overviews or general approaches, again as a generalisation. I'm starting at the other end. I'm starting with a detailed case study. Now, a number of things about this. That's not because I think generalisations are not useful or important. They are for certain purposes. But at some point in the analysis, if we want to make progress, we have to drill down to the detail. And if you've been with us over the last 2 days, it's a point you've heard me made in interventions already, that context matters. So that this is not just a question of a discussion between lawyers and philosophers, or between lawyers and forensic scientists, or between academic lawyers and practicing lawyers. It's all of those things, but it's also a question of the way in which these discussions and their implications are applied in the detailed context of particular legal systems. So what I want to do with my case example is to give a very rich, detailed, and therefore I'm afraid lengthy description of one case in the Court of Appeal Criminal Division in England and Wales. And already this is important. There's no such thing as UK law for these purposes. The UK has separate criminal law jurisdictions, just as the US does, and the jurisdiction that I'll be talking about is England and Wales. This is not a trivial point. The law of England and Wales is not the same as the law of Scotland, and the law of Northern Ireland is different again, and the law of the Channel Islands is different, and the law of the Isle of Man is different, ... So the jurisdiction that I'm talking about is England and Wales. I'm also not talking about Ron's antitrust cases or anything else. I'm talking about criminal cases, and specifically again, I'm talking about criminal appeals. I'm talking about criminal appeals in England and Wales. Now, already that's a lot of qualifications, right? And all these points making it very, very detailed and specific. But this, to my mind, is crucial. And again, just in the same way that we were talking earlier in the day about the importance of understanding Dauber in its particular context with regard to the particular questions that the Supreme Court faced in that particular case, you need to read, in my view, all case law in this kind of way. So this is a challenge. It's a big challenge. It's one I think of in particular that could be assisted by comparative legal studies and comparative legal analysis. One of the general methodological lessons that I want to advance in this paper is that these questions are as much about comparative legal studies as they are about questions of epistemology and questions of fact-finding at large. Context, then, is the key, and I don't know, there's a double-edged point here. On the one hand, I think it's excellent that legal materials, case law, is available to and read by lawyers in other countries, non-lawyers in other countries, non-lawyers in the UK, philosophers, epistemologists, whoever it might be, forensic scientists who have an interest in this material. It's great that we can pursue that conversation, but obviously there are dangers as well. The obvious danger is that you take general statements out of context, that you apply them to a new context in which they don't translate very well. So, yes, there is this interdisciplinary conversation, and I'm all in favour of it. But to do it well is not easy. So there are some, I hope, quite large methodological lessons in this one case study. Of course, having said that, it's only one case. We need to be clear about that. So I'm not putting forward any strong arguments about generalisability. I'm not saying that all criminal appeals look like this in England and Wales. I'm not even saying that all cases regarding scientific evidence are dealt with in this way. You have to be careful about generalisations from case studies. But case studies must be part of the analysis. We can't move forward here just by talking in terms of generalities. So, the study is detailed because that kind of thick description needs to be detailed in context. It follows that I can't give the paper, I've written it, you can look at it, it's only work in progress, it has the appropriate, please do not cite qualifications on it because it might be changed and developed and so forth, but what I can't do in an oral presentation, even though much longer, which I don't, is to give the paper. So what I want to try to do now is to talk a little bit about the paper and then open it up for conversation and questions, hopefully to some of you who have read it. So, just to get that discussion started then, let me just pick up some key points. I said it's one case. The case is called Henderson and it was decided by the English Court of Appeal last year. The case, as most of you will know from the title if nothing else, is about shaken babies. And in fact, when the appeal comes before the Court of Appeal Criminal Division, it's not one case, but 3 cases. Now, let's be clear. These were 3 separate criminal trials at first instance, but they were joined, or as we say, conjoined on appeal, so that the Court of Appeal dealt with all 3 cases at the appellate stage. They'd been separate cases at trial, but they were dealt with together at the appellate stage. And the reason that they were joined is because they were regarded, I think rightly, as raising similar issues. What similar issues? Well, in general, they were all cases in which the question was, had a parent, or in Henderson, a carer of a young child, an infant, injured that child through shaking, or had the injuries sustained by the child come about through some other accidental or at any rate non-criminal means. That was the question in all the cases. Was it criminal shaking or was it accident, or at least, you know, there was no reason to suggest that the accused was guilty of the crime. Now I'm being very careful about my language here because often these cases are homicides. Often these types of shaken baby cases result in the death of the child. In fact, in one of these cases, the child didn't die. The child fully recovered. But there was still a question, even in that case, about whether what had occurred was a criminal assault on the child from which they recovered, or whether, again, it had been an accidental injury. Already we see it's difficult to generalise about the typical shaken baby case. There are variations in them. But at any rate, the Court of Appeal, I think, rightly thought that these cases were sufficiently similar. More technically, they raised quite an interesting point of novel, we can say scientific, or more correctly, I suppose, medical scientific contention. The issue is this: can you infer from a set of injuries caused to a child that that child was shaken unlawfully? Is it possible to draw the inference from injuries to unlawful shaking? Now, more specifically, there are 3 types of injury that medical science tells us are important. Roughly speaking, the 3 types of injury are a kind of brain damage, bleeding in the brain, and bleeding behind the eyes. These 3 symptoms are known in the medical literature as the triad. And one way of describing what was at issue in Henderson and the other cases conjoined with it was, what's the probative value of the triad? Does the triad conclusively prove unlawful shaking? Is the triad some evidence of unlawful shaking but not conclusive? Or, well, it wasn't a possible theory, I suppose. It could have been no evidence at all, but nobody believed that. The medical science thought it was probative. The question was, how probative was it? Now, you'll notice another characteristic of these cases, which is that, on the face of it, you might be tempted to say that the medical evidence is the only evidence in the case. I think that's wrong, by the way, and I'll say why in a moment. But you might be tempted to say that the medical evidence is the only evidence in the case. It's more correct to say, in all of these cases, the medical evidence is central to the case. We can agree with that. The medical evidence is a central plank of the prosecution's case. Why? Well, think about it. The child is either dead or they're a young infant, and even if they survive, they can't give a testimony, they can't even speak, they don't have the power of language. So they can't testify as to what occurred. So even in the case Butler, where the child recovered, there was still no testimony from the child. In all of these shaken baby cases, it's characteristic of them, it's very characteristic of them, that the injuries alleged to have occurred when only the accused was in the company of the child. That's not always the case. Sometimes it could have been either one or the other parent, but typically, if it was unlawful shaking, it must have been this accused that did it. Added to that, often the criminal shaking is alleged to have taken place in a domestic, familial environment, normally in the family home, or if it's a carer, maybe in the carer's family home. The point being, for forensic purposes, that typically there are no other eyewitnesses, no other witnesses to the alleged incident. So in that kind of scenario, the medical evidence clearly becomes central. And as I've said, the issue, more specifically with regards to Henderson et al., was the question of the status of the triad. Okay. Now, I read Henderson when it was decided as part of my normal duties of being an evidence professor and having to teach this material, teach about expert evidence. And as I was reading, I thought, this case is a really rich case, raising all of the epistemological questions that we were debating yesterday about scientific uncertainty and how can you be sufficiently convinced to render a criminal verdict and a criminal case, verdict of guilty, what in practice constitutes epistemic warrant for a verdict, what in practice constitutes that. Also, fantastic questions about novel science and scientific uncertainty, because it was accepted in the case that the triad and literature regarding the triad was on the cutting edge of medical science. This was material about which the relevant scientific medical professionals were still debating these issues in scientific journals, in medical journals. It was the latest thing in medical science. The specific debate focused in particular on something known in the literature as the unified hypothesis. According to the unified hypothesis, what causes the triad is not shaking, but some single, unexplained medical trauma in the child, some underlying pathology in the child, some underlying illness. It could be unknown things, but it could be something else. But the hypothesis is that that one thing causes the three symptoms. If the unified hypothesis is correct, then the triad cannot be proof beyond reasonable doubt of shaking. You know, you say that this would constitute a reasonable doubt if that was a weighty hypothesis. These issues were directly at stake in Henderson. It occurred to me that it provided a practical illustration of all of the things we've been discussing, as I say, not only yesterday in terms of epistemology, but also today's discussion in terms of expert evidence, forensic science, and how the court deals with scientific uncertainty in a practical way. So, in general, I think the Court of Appeal does a reasonably good job of resolving these issues in this particular appeal, or these three appeals that were heard together in Henderson. And in the paper, I try and explain in detail how it achieves a result in the three cases. And by a result, I should emphasise right at the beginning that there is no retrial ab initio on appeal in serious criminal cases in England and Wales. So the appeal court is performing a review function. It's not retrying the accused ab initio as is common in continental European jurisdictions on appeal. That doesn't happen in England and Wales in serious criminal cases. Already we have a clue to the importance of institutional context there, and detailed institutional context. So, I know time's running on. The paper then, the main meat of the paper is split up into two sections, basically. The first section elaborates what I take to be the key institutional and normative features of criminal appeals in England and Wales. Those features explain what question the court had to answer, and doctrinally the answer to that question is, was the conviction safe? That's the question for the Court of Appeal. Was the conviction safe in each of these cases? We also then have to look at the powers of the appeal court in deciding whether the convictions in the instant cases were safe or not. And here, it's crucial to understand the institutional division of labour between appellate judges on appeal and juries deciding verdicts in first instance criminal cases. Now, clearly, we have two very differently constituted tribunals here. At first instance, we think of the classic English model of the Crown Court jury trial with 12 ordinary people off the street serving as a lay jury with a division of responsibility roughly between the judge who decides questions of law and the jury who decide questions of fact, roughly. That's the trial court. The appellate court is 3 appeal judges, no jury. So you have two very different tribunals here. And a key thing that's going on in this case is a negotiation of the institutional roles of these two very differently constituted tribunals. So there are only 2 possible outcomes. Well, I should say 3, actually. I'll explain. There are 3 possible outcomes from the Court of Appeal in hearing the appeal. Either, first, it finds the conviction safe and it upholds the conviction. That's possibility number 1. The conviction is upheld. Second possibility is that it finds the conviction unsafe. At that point, typically it will refer the case back to the first instance tribunal to be retried. It won't decide the matter because it can't. It's an appeal court. Only trial courts can decide these things in England and Wales, generally speaking. I should say, the third possibility, though, is that for other reasons, where you get an appeal that's allowed, the conviction is unsafe. If for other reasons it's felt that retrial would not be in the interest of justice, then at that point, the accused is simply acquitted and he walks away. Now, we have an account of what's in the interest of justice there. I mean, typically, for example, if the offence was a very long time ago and all the relevant witnesses have died or evidence has gone missing or there's been highly prejudicial publicity against it, in those situations, there might not be a retrial. But often, these days, there is. So the basic 2 options then are either conviction upheld or conviction quashed, appeal allowed, retried. That would be the typical model. Now, what you see there is respect for jury fact-finding, essentially. It's the jury in the English model of criminal adjudication which, in serious cases, decides questions of guilt or innocence, not the Court of Appeal. So the Court of Appeal, and there's a direct analogy here to what Marina was talking about in terms of the status of the judge as the expert of the experts. What's your phrase there? Peritus? Yeah, right. So there's a functional equivalence here because the Court of Appeal at least in theory, cannot usurp the role of the jury in fact-finding. Only the jury can find facts. So what the Court of Appeal has to do is to find reasons of law to decide whether the appeal can be allowed because the conviction is unsafe. So in simple terms, to go to the Court of Appeal and say, I am innocent, I didn't do it, that's not a ground of appeal in England and Wales. The answer to that is the jury's already decided that question. What we need to know on appeal is either was there a legal error in the trial, or is there fresh evidence that the jury did not hear, which calls into question the validity of their verdict.
Just to clarify, so you don't have sufficiency of the evidence appealed? There's no sufficiency of the evidence?
What we have is a kind of joker in the pack, which is not a matter of argument, but it's a matter of decision. You can't make insufficiency of evidence argument per se. What can happen is that after going through all of this, the Court of Appeal can say, we have a lurking doubt. And on the basis of a lurking doubt, we quash the conviction. Now that's just a joker in the pack. I mean, it's a kind of functional equivalent of insufficiency of evidence. But it's not used very often. And the fact that it's not used in Henderson, in this example, shows how rare it is, actually. It illustrates that point. So, all of this means that the Court of Appeal is constrained to look for legal error or indeed fresh evidence in criminal appeals, because it can't just change the facts or fact-finding. Okay. So what happens then in appeals around scientific evidence is that precisely the appellants make the argument either that there was legal error in the trial. If there was legal error in the trial could be quashed, they win the appeal, and or we have fresh evidence. Now, fresh evidence is an interesting concept because, of course, as we all know, you can endlessly individuate pieces of evidence so that it appears to be new. This is infinitely possible. So then you get a certain amount of fencing in the cases between, is it fresh evidence, isn't it fresh evidence? At this point, a further consideration comes in, which is not only about jury trial, but about adversarialism. And I explain this in the paper, but it's implicit in adversarialism that once you've chosen how to run the case at trial, you can't then just have another go on the basis that the trial strategy that you adopted at trial didn't work, so you'd like another go. Once you choose a trial strategy at first instance, you're pretty much stuck with it in England and Wales, unless, there are always exceptions, unless you can show that your lawyer was negligent or basically ineffective assistance of counsel arguments to show that it was your lawyer's fault or not your fault that you had this strategy at trial. So, this becomes really important in Henderson because there's a particular propensity to run the same argument again on appeal with experts. Why? Because expert evidence, and particularly expert opinion evidence, is essentially fungible. This is to say, if you have an ordinary eyewitness, right, to the crime, or an alibi witness, you've got to call that person at first instance. You haven't got a choice. You can't just get another alibi witness. I mean, criminal accused try to do that. It doesn't work that often. You can't just get another eyewitness. There was just the one eyewitness. That's it. You hear that person at trial, end of story. But of course, with experts, you try an expert argument at first instance. It doesn't work out for you. So what do? You get a different expert and you say, look, Court of Appeal, this is now fresh evidence because I have a new expert basically making the same argument. And again, you see in the Court of Appeal is very astute to say, the witness is fresh, the evidence isn't. We've heard that this is an argument that was made to the jury. The jury didn't accept the argument. Therefore, we're not interested. It's not fresh evidence. And you see this is going on in the case. Final point on this first area. It will be of interest, it's already been mentioned to me, it will be of interest to you to know that English trial judges are much more activist and interventionist than the traditional caricature of adversarialism would suggest. And I think it's true to say that they are also more activist and interventionist than trial judges in the US would be, as a generalisation. Differs from state to state, differs between federal and state, but as a general proposition, I believe this to be the case. Ron's not. So you need to know this, because the significance here is that English judges sum up to juries not only on the law but also on the facts. Moreover, they have to give detailed analyses of the facts that have been presented in the case and the way in which the law applies to those facts. If the trial judge makes a mistake about that in the way that the facts are summarised or explained to the jury, that is regarded as legal error. Because it's not the jury, this is the theory, it's not the jury who's made a mistake, it's the judge. It's the judge in explaining the evidence to the jury that's made a mistake. That's a legal error. What's the significance of that? The significance of that is that the Court of Appeal can intervene with regard to legal error, not with regard to a jury error, pure and simple. And so we see a very interesting account of what legal error can mean in terms of factual analysis. And in these cases, particularly in the appeal that was allowed, which is to say Butler, and that was the case in which the child recovered, the appeal was allowed in that case. The court goes into incredible detail in looking at the way that the judge summed up the case. It finds that the summing up was defective in all kinds of ways, and it treats that as one of the reasons for quashing Butler's conviction on appeal, because the judge got it wrong. Got it wrong not with regard to substantive criminal law, got it wrong with his account of the analysis of the evidence. Okay, right, fine. Try and wrap this up now by saying a little bit about the second part. All of that first part, right, you might regard this as a very detailed set of institutional and normative rules and principles by which the Court of Appeal is enabled to dodge all the hard epistemological questions. All of these mechanisms allow the Court of Appeal not to get into epistemological problems. It can treat the issue as a problem of law and deal with it through, if you like, conventional legal analysis. So as I say in the paper, in all of these ways and other ways, I discuss at greater length in the paper itself, the Court of Appeal dodges the epistemological bullets, doesn't take on these questions. But in the second part of the paper, I go on to suggest ways in which the Court of Appeal engages much more directly with epistemological problems. It does this in a rather artificial way. Why artificial? Because we don't know what the jury thought. We don't know how the jury reasoned, because in our systems, I'm sure you're aware of this, the jury is a black box decision maker. In England and Wales, it is a contempt of court for which you can go to jail for a juror to divulge any information to anybody about what was said in the jury room. It is also a contempt of court to ask a juror to divulge anything that was said in the jury room. The jury room is a sacrosanct space. And I use the language advisedly there, the religious language, sacrosanct in legal terms. It's a black box decision maker. So all you get out of the jury is a verdict. By definition, the verdict in all of these cases was guilty. Why? Because we wouldn't be having appeals otherwise, because only the defence can appeal from a jury verdict. Acquittals are, with an exception I won't talk about right now, a recent exception, acquittals are final in England and Wales. You cannot appeal, the prosecutor cannot appeal a jury acquittal. So, by definition, in these cases that are heard on appeal, we're talking about a black box decision of guilty. However, what the Court of Appeal can do is to reconstruct how the jury could have reasoned about the evidence based on the evidence that was given in the case, the jury instructions that were given by the trial judge to the jury, and crucially, further information which the Court of Appeal can hear itself in the appeal process from expert, or indeed it might be, but not in these cases, other witnesses. So the Court of Appeal can call further information. It has to. If you think about it, if one ground of appeal is fresh evidence, then the fresh evidence has to be given in the appeal case. So that's what happens. Now, this is particularly significant because there are all kinds of institutional reasons why courts of appeal tend to defer to the judge's discretionary decisions, particularly in points of criminal procedure and evidence. Why? Well, according to the orthodox theory, the judge ran the trial, was there in court, heard the witnesses give their evidence live, orally. We know how important that is in Anglo-American theory, principle of orality, but also in continental process, principle of immediacy. So we have a similar idea. Given that the trial is such a different event to the appeal court judges tend to say, we defer to the judgments of the trial judge. They knew what was going on. They even say this, the trial judge has a better feel for the case. They say, feel for the case. A feeling is not something you can articulate. You can't say more than that. This is a unique trial event which the Court of Appeal does not seek to replicate or second guess. However, it's different with experts, because expert testimony is one area where arguably the Court of Appeal might be in a better position to make a rational decision in terms of any scientific dispute, for all kinds of reasons to do with the fact that often the parties are better prepared for appeals. They now know this is a serious case, or a case that raises novel issues. They might well research the issues more, they might get more experts involved, etc., etc. So in this one respect, conflicts of scientific evidence, actually the appellate process might be a better process than first instance cases for the specifically constrained institutional purposes of deciding whether the conviction in this instant case was safe or not. That's the question. So in these ways, the Court of Appeal engages with these issues, and specifically it needs to discuss the probative value of the triad, needs to talk about the unified hypothesis, and it also gets into a discussion about other issues. So in one case, one of the defence experts says, maybe the deceased child had undiagnosed HIV/AIDS. Maybe their injuries, this child actually had 2 of the triad, not all 3. So they had brain damage and they had bleeding, but not, I think, bleeding behind the eyes. Maybe it was caused, says this one expert witness, by undiagnosed HIV. If that was the reason, then it wasn't shaking. Therefore, you can make the argument that the appeal should be allowed and the conviction quashed. So all of these issues were ventilated on appeal. And I show in the paper, again, I think, how the Court of Appeal does a reasonably competent job, I think, a reasonably good job of thinking about what would constitute, I didn't say this because this is obviously theorist language, but what it's doing, in practice, what it's doing is deciding whether there is adequate epistemic warrant for these verdicts in these cases in English criminal proceedings. That's exactly what it's trying to do. It's not fazed by scientific uncertainty. It embraces it. It says we know that this is an uncertain area of science. We look at this and we're trying to apply it. We've looked at the different conflicting expert witnesses. We haven't said to ourselves which expert was more articulate, or even which expert was more senior, or even which expert was more attractive. These are all theories about how the jury actually resolves conflicts of expert testimony in completely irrational ways. And this is the critique, that the expert disagreement is resolved in completely irrational ways. Court of Appeal doesn't do that. It embarks upon a fairly systematic analysis of what it can find in terms of whether the evidence proved a particular proposition, whether it was the only evidence in the case that proved that It never is the only evidence. Why not? Because at the very least, you've got the testimony of the accused saying that they didn't do it, which you did have in all these cases. Even if you don't have that, you have the fact that the accused on trial and they didn't testify. So there's always other information in criminal litigation, always other information that the fact finder has regard to. So there's no such thing as simple scientific proof. It always has regard to the full context. And finally, the Court of Appeal used what seemed to me to be perfectly rational reasons for discounting the testimony of certain experts. Not irrational reasons. So let me just conclude with this example that I've just given you. In the one appeal, the Oidiran case, the third of the three, where it has to be said the evidence of criminal wrongdoing seemed to be stronger. There was evidence of the accused propensity to violence, his attacks on other people. There were other issues with other injuries to the child. There was other evidence in the case, as well as medical issues. And on appeal, as I've already said, one of the defence arguments had been, what if it was undiagnosed HIV? And that expert actually said to the defence lawyers, the person you need to speak to in England is this particular paediatrician. She's the expert on HIV in paediatrics, in children. You need to speak to this person to resolve this HIV. So the defence, duly, because this is a big appeal, an important case, a murder case, the defence goes and consults this very expert that the first expert had said you need to talk to. The second expert, the world's authority, says no. There's no evidence in the pathology whatsoever of HIV. Also, the first expert, Dr. Squire, she suggests that the mother of the deceased child might also have had undiagnosed HIV. By the way, all of this is coming from the fact that they were Nigerian. And her theory was, well, there's lots of AIDS and HIV in Nigeria, maybe they've got it. That was her theory. That was the defence argument. So, okay, so she also makes the argument, the expert, the defence expert on appeal, that maybe the mother had undiagnosed HIV as well. The prosecution has actually got the mother's family doctor as an expert. The family doctor who treated the mother, she had serious multiple sclerosis, she had ongoing medical problems. The GP who examined her, treated her, done all the tests and everything, the GP is saying the mother has not got HIV. There's no evidence of it, there's no symptomology. When this is pointed out on appeal, and partly through cross-examination, to the first expert, she still refuses to rule out the possibility of undiagnosed HIV in both the mother and the baby. At which point the Court of Appeal says, well, what are we to make of this? We've examined this, we've asked other experts, it's all been pointed out to you, and you still refuse to accept the point. Seems, well, of course, we've only got the Court of Appeal's account of this, we don't know really what happened at trial, but it looks like, the way the Court of Appeal tells it, that here we have an expert who is either kind of fixated on this theory and just won't let it go, or has some wrong-headed notion of adversarial procedure according to which you must never concede anything to the other side, you must keep hammering on at your theory, whatever happens in an adversarial system. Whatever it is, it was very bad tactics on appeal not to concede the point. At which point the Court of Appeal, in my view, perfectly rationally discounted the testimony of the first expert, the one who kept banging on about HIV. She could not be believed. Her evidence did not supply sufficient epistemic warrant as part of a criminal, as a challenge, I should say, as a defence expert, as a challenge to the safety of the conviction. There was nothing in her argument which would constitute unsafety in the conviction. So, not 10 out of 10 for the Court of Appeal. If you read the argument in the paper, I do make criticism of the Court of Appeal's reasoning. What I do say, though, is it makes a reasonably good fist, which is actually misspelled on the paper. It says first, but it meant fist. Reasonably good fist of these particular appeals in this particular context. It did not stumble over the types of problems that in one kind of literature in this area one encounters very often as being, the argument is, the law can't cope with science, the law is incapable of taking on board scientific knowledge, science is open and forever changing, law is closed and needs a final verdict, therefore they're fundamentally incompatible. That's not what happens in Henderson. In Henderson, the information is used in a perfectly rational way and evaluated, it seems to me, in a perfectly rational way as well. Again, with conflicts of experts, once more, it's rationalised in a perfectly straightforward way. So, I conclude in the paper, I'm not saying that English law's approach to this is by any means perfect or beyond reform possibilities. Indeed, there are a number of reform possibilities on the table right now in England and Wales, including a reception of a kind of Dauber. It will be an explicit gatekeeping function, and that act right now is before Parliament. If it gets passed, it will be the Criminal Evidence Experts Act 2011, and it will require judges in England and Wales to undertake a gatekeeping function with regard to expert evidence. Not, notice, scientific evidence, because I managed to argue them out of that, but expert evidence, which is the correct approach, in my view, for reasons we've already looked at. There are all sorts of other things that could be looked at, procedural improvements, ethics and so forth, more training, more information, more education for lawyers, for scientists. All of this is important. What I hope this one example has shown is that many of these problems of high theory can be satisfactorily resolved in practice, it seems to me, in particular cases, not always, but often, sometimes, at least in this case. And in terms of methodology, the exercise at full length is meant to show the kind of detailed, thick description that you need to engage in order to understand what courts say in a common law system of precedent. Even that's only part of the picture. Ultimately, you should also think about the empirical realities, what really goes on at trials, socio-legal information. You also have to have regard for things like professional, judicial and legal culture. All of these are dimensions in understanding a fully thick description of what happens in these cases, but I hope to have shown you today that at least I've made a start on how one might achieve that kind of approach in the paper that you've read. Thank you very much.
Thank you, Paul. The debate is open.
And I can start us off.
Can you use the microphone?
Sure.
Why stop now?
See, it's still not on.
No.
Yeah, there we go.
Oh, excellent.
So just a question, just from a criminal proceduralist perspective, and then maybe a comment. It seems like devastatingly bad lawyering, not just a mistake, but allowing this witness to continue to persist in something that would have completely ruined her credibility that should have been able to be checked in some way or the other. I mean, maybe not, but was the mother hostile to the caretaker, so you couldn't ask the mother, do you have HIV, or?
Mother was deceased.
The mother was deceased. No access to the doctor who then testified that she didn't have HIV.
Well, the way that the court tells it is that the expert we're talking about, Dr. Squire, she just didn't know this stuff. She just wasn't prepared. And it was under cross-examination. All this stuff came out, and she refused to accept any of it.
But in addition to this point, there's a factual issue here. Wasn't there tissue to be tested? Records to be checked, something to be done.
With regard to the child, yeah. I mean, after all, the second expert, the real expert, was only consulted on the advice of the first one. And they had the pathological slides and all the rest.
Well, that's why it sounds like devastatingly bad lawyering. I mean, but in any event, so what is interesting here, I'll just throw it out, is that there is this concept of evidence, that evidence is what is presented at trial, and usually takes two forms, testimony and things, documents and so on. In fact, it's not a very useful concept of evidence. I mean, a much more useful concept of evidence, regardless of its technical correctness, is that evidence is an interaction between whoever is deciding the facts and whatever happens at trial. But that interaction involves the person's background knowledge, experience, and so on. And why I make this point is, well, two things. Number one, throughout the couple days, we've been talking about evidence, and it makes a difference which of these concepts you're thinking about, whether you're thinking about evidence as a testimony and things at trial, or whether you're thinking of it in a more interactive way. And this case, in a way, is a good indication of the distinction that one way to understand it, and I'm not saying that this is right, I have no idea what's right or what's wrong, but if had this happened in the United States, what we would be thinking is that doctor was a really good signal that her lack of competence or obstinateness or whatever it was a really good signal that you have a really crummy case. And so that was a signal that itself was evidence of, or could be thought of as evidence of the truth or falsity of the claims that they're trying to support. So that the obstinateness, which you wouldn't normally think of as evidence, really was maybe the most powerful evidence. Now, I'm not saying that it was, Paul, but I'm saying that's one way to understand it. So that, something you would never think of as evidence really is. But why is it? This is why it's interesting. Why it is that interacts with the conceptual framework of the decision maker in such a way to lead to a certain inference. In this case, the inference of guilt, apparently.
Unsafety would be, because this is taking place at the appellate level. Yeah, absolutely. I mean, I do advert to this briefly, but in a way that wouldn't be picked up if you didn't know, in a footnote in the paper. I mean, as we say in Roberts and Zuckerman, I'm perfectly open to the view that information is a better concept analytically in many ways than evidence, precisely because evidence for lawyers has a technical meaning. It means something like that which is admissible and can be used as a basis of motivation for a judgment or whatever it is. Whereas clearly any fact finder, whether it's a jury or a professional judge or an appellate tribunal, is exposed to a great deal more information than what is technically evidence in the case. I mean, a very, very striking example is the fact that in England and Wales, the accused sits throughout the trial in the dock, in a box in the court. There he is. That's not done universally. I guess in the US they sit behind tables, do they, mostly?
Actually, there's all kinds of concern about the manner in which they sit behind the table. Like, you can't, unless they're just mad, crazy dogs, vicious and so on, you can't handcuff them, you can't let them be seen handcuffed in the presence of the jury, you can't make them go in wearing these prison jumpsuits, anything that would communicate through this method that they're the accused, even though you know where the accused is, right there next to the lawyer. You can't do that.
Well, it's not so long ago, I mean, it's a few decades, but it's not so long ago that in many courts in England and Wales, the accused was brought up through a hole in the floor from the jails underneath, often shackled, and they were referred to as the prisoner. And we don't do that anymore. we moved that far. But in any event, remember that even when it's said that the accused doesn't testify in his own defence or her own defence, which they often don't for actually very good strategic reasons in many cases, they're still there in court, they're still listening to the testimony that's given against them, they're still confronting witnesses, and the jury is watching them. So that's not evidence in the technical lawyer sense, but it sure as hell is information. And the jury will be having regard, and that's just one example. Just another very brief one, is that according to behavioural scientists, social psychologists and others, the sort of people that do story model type work, they say that maybe 30 to 40% of the information that juries rely upon, juries bring with them in terms of assumptions, common sense generalisations, etc., etc. Now, I don't care whether it's 30% or 20% or 60%. I'm not bothered about the numbers. You'll have gathered that about me by now. The point is that even according to orthodox theory, right, jurors are supposed to be common sense reasoners in England and Wales. That's why giving them likelihood ratios is hopeless in England and Wales, because common sense reasoners don't know what to do with likelihood ratios. Now, it follows from that they're supposed to know lots of stuff. In fact, sometimes, I put the point slightly provocatively, but I sometimes say, in our system, the jurors are experts in common sense. That's what our system believes. And this is not trivial. This is a foundational assumption. It's part of the architecture, the institutional architecture, or the institutional technology of English criminal adjudication, that's what the fact finder does. So the judge can never ever say, oh, you know, jurors, this is too hard for jurors, you'll never work this out. The assumption is that if it's common sense, the jury is king. So all of these reasons show that the fact finder has lots of other information. And I do talk about this a little bit in the paper, because I mentioned the fact that in the Henderson case, the first one of the three, Henderson, this was a case, if you've read it, where it was a childminder, not a parent, that had allegedly harmed the child. She was a professional childminder, registered childminder. She'd had lots and lots of other children in her care. They'd never been harmed, as far as anybody knew. She'd raised 2 children of her own. No indication of child abuse or harm there. And so, after all the case, we're left with this enigma on the face of it. Why would a respected childminder, experienced childminder, why would she suddenly shake a child in a violent way and cause that child's death? Why isn't just the fact of that scenario enough to be reasonable doubt? Well, there's an answer. The answer is partly to do with common sense generalisations, and I spell these out in the paper. We know, for example, that people sometimes do things that they don't normally do. In fact, we have a phrase for this. We say they act out of character. We also know that people do things for the first time. I guess everything you did at one point was for the first time, right? So, the fact that she'd never done it before may be indicative of an unlikelihood that she would do it, but it didn't show that she would never do it in the future. Also, we know that these incidents can happen spontaneously. You know, it could have been over in a couple of seconds. A quick shake might have been enough to kill the young child. In fact, this is an important part of the medical evidence read in context, because an interesting thing about shaken babies, these cases that are the shaken baby cases, are that the shaking must have been violent enough to kill the child, in most cases to kill the child, and as part of that to cause the triad, which is often indicative of these cases. But and that means it must be more than the kind of general shaking and knocking about that children get. You know, little children, they fall downstairs, they fall off swings, they fall off chairs. Things happen to them, and thankfully most of them don't die, most of them don't get the triad. So it must be more than that. But it can't be so violent that, I mean, it gets a bit nasty now, but so that, for example, the child's head was shaken off. It can't be those injuries. And actually, so the shaking that's caused in the triad is kind of medium level. It fits within a narrow band. It's not violent enough to really, you know, cause external obvious injuries, but it must be more than average knocking about that children get. So it's quite narrow. So all of this was unlikely, but at the end of the day, the court was able to draw on common sense generalisations that these things can happen, even an experienced childminder could do it. It only takes a minute or a few seconds of loss of control or of anger or whatever it might have been, and at that point it could have happened. And here's the coup de grace. Why is that sufficient epistemic warrant? And the final answer is that's the very argument that's already been put to the jury. So the fact that we, the Court of Appeal, are still a bit, we're still not totally sure about this. The argument has been heard. The jury decided, and that is adequate epistemic warrant in our system.
That's all? Nothing else?
Surely more questions. I'll be quicker in my answers, I promise. You can't trust my promises.
Also in the public. Giovanni,
Just could you add something?
use the
on-
microphone, please.
I promise I didn't turn it off.
Could you add something on cross-examination in this case? If I understood it correctly, you said that there was a cross-examination which was very, very important for the final decision. Was it right?
Well, look,
And so the idea is that you think that this is a good lesson for the idea that, as Whitmore said, cross-examination is a good method, maybe the best method for the discovery of truth, or machinery or engine. I don't remember the word he used, but yeah, engine. Yeah.
yeah, finest legal engine ever created for the discovery of truth. When Wigmore wrote that, he was absolutely serious. Over the last 20 years or so, whenever you see that, and you can do this for yourself, you can look on Westlaw and do a search for that quotation. You know, just search for finest legal engine or whatever your final quote. In the last 20 years, that's mostly been quoted to show what idiots lawyers are. Right? It's mostly been quoted by behavioural scientists and psychologists, social psychologists, as proof positive that lawyers are idiots. Okay, now Roberts. It's time for balance. The greatest legal engine, I don't know. But is it sometimes useful? You bet. Any practicing lawyer will tell you that on occasion they've managed to make headway. And in this case, remember, specifically, if we're talking about this particular example, this was a cross-examination in front of judges, not jurors, who's on appeal. Right? It's important. So all of that grandstanding and rhetoric that you see on American TV programs, and England doesn't necessarily look like that. Okay? None of that would have been going on in the Court of... I've sat in the Court of Appeal and listened to cases. It's dull. The judges are not interested in, rhetoric or... they're not interested in any of that. The jury might like it, maybe, but the judges in the Court of Appeal don't want any of that. They want the argument, and they want to hear the information. And the judges themselves would have been asking questions of the witnesses, no doubt. They would have not felt any inhibition on appeal, no jury, to directly saying to the witness, what do you think about this? What would you say to that piece of evidence? In fact, sometimes the judges almost take over the cross-examination from the parties, on appeal in particular. At first instance, they have to be careful. If it looks as though they're undermining the lawyers, particularly the lawyer for the defence, there's going to be an Article 6 fair trial point coming. So that in front of the jury, the judge has to be a bit careful. On appeal, different rules apply. So it seems from the case report, which is what I'm working from, not the trial transcript, the case report of the Court of Appeal process, it seems as though the witness was given ample opportunity to learn about these new facts, to recalibrate her evidence, to say, OK, in that case, if such and such an expert has already looked at that, that's fine. She didn't say any of that. She still insisted, no, it hasn't been ruled out. At which point, the judges just thought, well, we can't trust you then. For whatever reason, you're just not acting reasonably, rationally. So, final point on cross-examination. Cross-examination is not just a legal principle in England and Wales, and I suspect in other Anglophone countries either. It's very interesting. We've had a number of inquiries into the Iraq war. Is the war legal? These are public inquiries. Should the government have backed the war? Tony Blair's decision to go to war. When these inquiries are set up, if it's not going to be a judicial inquiry with lawyers, but a more informal, inquisitorial approach, all the newspapers will immediately report the criticism. How can this be a proper public inquiry if there are going to be no lawyers to conduct cross-examination? That's not a lawyer's point, that's a journalist's point, and they're not addressing lawyers, they're addressing British people, British culture generally. So when you talk about cross-examination, it's not only a question of efficacy. Is cross-examination truth conducive? It's not only even about whether it's fair to the accused in terms of due process rights, and now, as we know, Article 6, fairness. It's not only about that either. It's also actually about epistemic warrant and legitimacy of verdicts, because the British public more generally expects that testimony will be cross-examined in serious criminal cases. Imagine a scenario in England where someone said, OK, in future, look, let's... Final reference, I hope. It's an important topic, but not a pleasant one. Final reference to the rape example. We know these cases are very difficult. We know that many people regard conviction rates as too low for rape, too many rapists get away with it, whatever. Suppose someone were to say, OK, in future, the complainant in a rape case will not have to undergo cross-examination at all. Their testimony will simply be written down and it will be taken to court and read out. Now, first of all, Strasbourg wouldn't accept this, but let's forget European Court of Human Rights for a minute. Just treat it as just a hypothetical. Even outside legal doctrine, it would be unacceptable in British society, because it's expected that important witnesses, including complainants in a situation like that, will be subject to cross-examination. So it's cultural and as well as legal.
Okay, I think that it is time to close. I want to express that we are very grateful, not only with Paul, but also with all the speakers for your knowledge and your kindness these 2 days. It is very, very interesting for all of our, and very encouraging to continue the work on evidence here in Girona. Then thank you, all of you. And it is I have to express my grateful also to all of the colleagues in the Girona Group of Philosophy of Law, and especially to Carmen Vázquez, who is the very organizer of this workshop. Thank you so much.